right, good afternoon. Hope everybody had a good lunch. What were we able to sort out with regard to other potential co-conspirator statements? Identifying those.
John, we have a list of potential ones.
Okay.
Sort of a broader universe. And I'd like to narrow them down before handing them over. Some of them we have reviewed and they have statements about drugs that we may not want to introduce. So there's a large volume of, for instance, calls that have certain commentary in them.
Okay. So you can identify the statements and you're saying that it may be less than the full statement and you can further narrow that, but you at least at this point have the person and their statements.
Yes.
Okay.
Up to a point, yes.
Okay. Up to what? You can go ahead and continue to explain.
So, and that's the way it is with a number of the jail calls and the calls from the wiretaps that we have reviewed.
Okay. Okay.
There are some that are left unreviewed, but the ones that we reviewed.
Okay. And for the ones that are left unreviewed, can you identify, here's the person and here's their universe of statements? We just can't tell you what portions yet. Do you understand what I'm asking?
I think I do, and I don't think that you can. When you said, if you could just clarify.
Okay, so why don't you do what you can right now, and then I'll ask you the rest of it. So as to what you have prepared, let's go ahead and share that.
Okay, so this is much in the way that Mr. Atkins was a list of
Right.
54 calls.
Okay.
Similar. It contains
You don't have to count the number. You can just go ahead and give them the notice.
okay.
Is it something that you have like a written list?
So yes, it's an internal list of notes
Okay.
and calls that are identified.
Okay.
So what I can do is provide to them just the calls that are identified.
Okay. So do you want to do that in writing?
Yes.
Okay. So do you want, could you at least in court identify the witnesses?
So So when you say the witnesses, you mean who we're going to be introducing through?
No, that's not what I mean. I mean, who is the alleged co-conspirator whose statement you think you're going to use? And if you have the witness you're going to use, I get it in through, that's great too. But we're looking for co-conspirator statements. So we need to know the ID of the co-conspirator. Okay.
So mainly the ones from the Garlington wiretap are the ones that are identified in a majority. That's the ones that we have the majority of. The remaining jail calls that we've identified, they are jail calls of Diamante Kendrick, Martinez Arnold, Shannon Jackson, all of whom are actual defendants who either are currently in trial or who have pled, and Marcus Nichols.
I'm sorry, I didn't, number one, I didn't hear that. Sorry, I just couldn't
Okay.
hear it. And number two, my original objection just was,
Is your mic on?
my original objection was too little, too late. In other words,
I understand.
okay.
I'm just
so-
trying to sort out what there even potentially is at this point, and then, which is harder than it should be. And then I will hear why it hasn't been shared before and why it should now be permitted regardless.
Thank you.
Thank you. So can you say those four people again louder so Mr. Harvey can hear?
Yes, Your Honor. The jail calls, the jail calls of the persons that I have in my hand that we're reviewing are jail calls of people who are currently on trial or who were on trial and entered a plea.
Okay.
So I don't think that counts for what Mr. Harvey is talking about in terms of co-conspirator statements. In other words, for instance, I have Mr. Kendricks, Mr. Stillwell, Mr. Nichols, jail calls that we had under review by the team who was working on that. And that we've identified calls from that we intended to use.
If I may respond to that, if it's Mr. Nichols' phone calls, the kid has been in jail for a couple of years, number one. Number two, those are his statements. I'm entitled to those under the discovery statute. And if they're just looking at them now, 2 years later, you should, without any question at all, exclude those. I mean, this is,
Okay.
come on, 2
So-
years later.
It is my understanding that everything that my understanding based on your representation to me earlier today in court, that everything that you intend to use as a co-conspirator statement has been provided to the defense in discovery. Is that correct?
Correct.
Okay. And so what we're doing now is y'all asked that it be identified which are going to be co-conspirator statements. So it's not that you don't have it, it's that it has yet to be identified as a potential co-conspirator statement. So with regard to your objection about not having it, you have it, it sounds like. Now, if it's a statement of one of the defendants on trial right now, but it is going to be used against another one of the defendants on trial right now, it is, right?
Yes.
Then it is a co-conspirator statement. So, Mr. Nichols, Mr. Kendrick, Mr. Stillwell, you also said Mr. Arnold and Mr. Jackson. And did you say that both of those people have pled?
Mr. Arnold has pled.
Okay.
And I said Jackson, but Jackson is Stillwell, so that was
okay.
a statement.
All right. So the only person you've identified other than the three that are on trial right now is Mr. Arnold who pled.
Right. And there's also Nichols, Kendrick, Stillwell. And I have a jail call from Quindarius Zachary.
Okay.
We've identified.
That you've identified only now, not previously. So don't tell me that the three that were already identified, they don't have an issue with in terms of it. Late notice, yes. So was Zachary one of the people that had been identified in that November 2023 notice? Because the notice I have says person A, person B, so I don't know who they are.
Right. So Not the jail call, the statements that he has made, but not the jail call. So the name, I believe Zachary is either A, B, or C. I have to look at our notes.
Doesn't matter who. Yes, he was identified as one of the people whose co-conspirator statements you intended to introduce, but the jail call wasn't identified within there.
That is my.
Okay. Is the jail call subsequent to the time that you provided the notice?
No, the jail call date is 2015. It's in 2015.
Okay, so is there a reason you didn't include the jail call in the notice that you provided?
When we were preparing the notice, our understanding of the need to extract jail calls that contain this information or wiretap calls that contain this information and identify them was separate from our obligations regarding generally what co-conspirators say.
Okay. Can somebody provide me either the order, oral or written, or the directive that the court gave to the state so that I can figure out whether that was a reasonable interpretation?
And we're going to get that for you. And at the time that we were under the obligation to present the co-conspirator statements, we were still, and the court was aware, we were still listening to, because there was an ongoing commentary about the jail calls and the number of them and identifying them. So we were still listening to.
Okay. So at some point, presumably you completed your listening. I mean, I know they're still ongoing, so I'm not talking about a jail call somebody did last night. But
even
okay.
All of the ones.
Do you understand? I'm sorry to interrupt you, but let me back up and ask a different question instead. Did you understand that you had a continuing obligation to notify of co-conspirator statements, even if it didn't include jail calls and wiretaps?
Yes.
Okay. And with regard to whether there was some other understanding about jail calls and wiretaps, I'll sort that out later. Let's, at this point, are there other people who you think are co-conspirators, who you think you have co-conspirator statements for that you are potentially going to want to admit in this trial? And let me direct your attention to, because this might help you a little bit. You, a couple of days ago, provided at the court's request to the court, and I assume to opposing counsel, a kind of modified list of witnesses still to go. Mm-hmm. All right. And you have at least a broad outline of evidence you expect with those witnesses. And some of these people you have actually identified specifically as co-conspirators. So, I mean, can we go through that and at least with regard to those people, see whether, yes, in fact, there is potentially such a piece of evidence? All right. Yes. So, if everybody wants to follow along and pull out your state's witness list. The first one that I notice is number 3, Antonio Sledge, who you say is a co-conspirator, and then on your evidence you have listed a defendant interview and a jail call. Right. Could that potentially be?
Yes.
Okay.
Yes.
So we can add Sledge to the list. Then Zachary, you mentioned, so he's already on our list. Now, some of these I just don't know, but there are a lot of them that have interview or something like that over to the side. I mean, somebody like number 7, Kenya Morton. I don't think she's a co-conspirator, but okay. And then Arnold, who's number 27, you mentioned. How about number 35, Wooney Lee, who you have labeled as a co-conspirator?
He is.
Okay, and are there potentially co-conspirator statements from him?
So unless, what we have of Winnie Lee consists of social media
Yeah.
evidence. So arguably, if that could be considered co-conspirator statement.
Say better to say yes, I think so, and it not be than the other way around at this point. I think it was 35. 33. It says 35. Oh, no, it says 35 on mine because I got what, today maybe? Or yesterday afternoon, an amended witness list that adds a few people.
And Your Honor, for the record, it added 2 custodial records for
Okay.
Sprint and T-Mobile.
Okay. So anyway, Winnie Lee, either number 33 or 35. How about, and you mentioned Sumlin earlier this morning, and Sumlin y'all already had notice of from November of 2023. So Sumlin's okay. I mean, that may be it in terms of, in my review over lunch, what I noticed to be pretty obvious ones. Are there other ones?
As we're reviewing And Your Honor, I think I took it for granted, but all of the 6 co-defendants currently on trial, their statements, their social media, and the jail calls that they have, that we have of them,
Okay.
would be
All right.
considered co-conspirator.
All right. And I'm think that with regard to the 6 co-defendants on trial, it is, I mean, pretty obvious considering that there's a RICO count as well, that the state considers those people to be co-conspirators of each other. It still might be helpful to identify the statements, but with regard to deficiency of notice as to those people, I'm going to say that's okay, that's kind of within the context of there being a RICO count against them all. That notifies the defense that at least you think they're all co-conspirators. So if you can identify the statements as well. So that leaves, I guess, so does that mean that there are no others other than the ones we've run through just now?
I want to say that that is accurate. I want to be accurate before I say that that is accurate.
So while she's making sure she's being accurate now, somebody else can tell me, so on the notice that is from November 2023, the two people who are they? Zachary and Sumlin, the people that are identified as like person A and person B? Everybody seems to know except me at this point. I mean, y'all know at this point. So how about somebody on the defense side tell me? And you don't even have to say who's who, just. Oh, okay. Mr. Weinstein, you're looking at me like, I know, but.
Like, this seems like a job for Max Sharp.
Apparently it is, because here he comes.
I'm looking at, am I correct that you're asking about this notice of the three?
Yeah, there's I don't know what it says, witness A and witness B, or person A and person B. And then y'all said, or she said, there was a supplement that actually identified who those people were. So,
Your Honor, witness A was Mr. Copeland, and in that notice, we talk about the statements that Mr. Garlington made to Mr. Copeland. Witness B was Quindarius Zachary.
okay. All right.
And he's talking about statements that were made by
All right.
defendant Stillwell and defendant Kendrick.
Okay.
And
Yes.
I agree with 1 and 2. 3, I'm not sure has played out in actual testimony.
Okay. Do y'all know who 3 is?
I think it says Donovan Thomas Sr. to his brother, but that wasn't co-conspirator.
There's only an A and a B that are like not identified people, right? Okay. Okay.
But 3 is not a co-conspirator statement, correct? Okay,
Okay.
so there's only 2 co-conspirator statements, alleged co-conspirator statements.
Okay. All right. So with regard then to
Damone Blaylock, Your Honor, there are statements that are made, well, there's social media that we have identified. Damone Blaylock is a defendant in this case who's been severed.
severed. Okay.
He, social media from the incident listed on the indictment that he was already tried for with one of the other defendants currently on trial.
Okay.
Those,
And Lee is also a severed co-defendant, right?
Lee, yes.
Okay. How about Sledge?
Sledge is a co-defendant that already pled guilty.
Okay. All right. Yes.
You might want to know Mr. Lee, Warren Lee, he resolved this case.
Okay. But I mean, he was at one point part of this indictment,
He was
the big indictment. Okay. All right. So then really for everybody that was a part of this indictment, everybody was charged under the RICO count, right?
Yes.
Okay. So it will come as no surprise that the state thinks they are co-conspirators because the state literally alleged that in the indictment. So at this point, there is an objection that they don't have notification of what the statements are. And we are several months in. How quickly can you get to them the detail about what you think co-conspirator statements you intend to introduce? Go ahead.
Your Honor, not certain what amount of time the court's willing to allow us to identify anything not already identified or in the indictment. I don't know if a week exceeds what the court is willing to give. It's what we would ask to identify within the discovery already provided.
Right.
Identify specific statements that are there. We would ask for a week to identify
Right.
that.
All right. Understanding, Mr. Harvey, your objection to delayed notice, I am going to overrule that objection right now to the admission of the evidence. We, of course, still need to know what the actual evidence is. And a part of the basis for me overruling that is that it appears that the whole trial has kind of been operating on a rolling basis with regard to the evidence. And there have been orders even that, hey, every other Friday, let's talk about the evidence that's coming in for the next 2 weeks. And so if that's been the understanding, then so be it. But I want that to stop right now, which is why we are going through in what I consider to be painstaking detail, because this really should not be what the court is spending its time doing. This is what y'all ought to be doing on your own. But I want us to get on a track where the litigants know what is potentially coming in against them, less than here's the universe. And I want us to be efficient, but I don't want y'all, anybody, either side, having to try the case sort of, blind, or practically blind. So now that I hope we all are getting a better understanding of how it ought to work moving forward, I am going to give y'all, because I've given y'all a lot of other tasks as well, 1 week until next Thursday to get all of that in detail, including anything in wiretaps, including anything in jail calls to the defense. Okay. You look like you want to say something, Mr. Steele. Okay. All right, you're welcome. Okay. So, what else can we get done today?
Your Honor, just to address a matter that the court asked me about before lunch. The court had asked when I represented that my understanding, if I'm not mistaken, was that the matter of disqualification of a judge was not competent evidence to be used in the trial. I think I said something akin to that.
Yeah, and you said you had some kind of law that you could provide to us.
What I referred to was Georgia Uniform Superior Court Rule 25.6 and my understanding of it.
Okay.
If it's different than the courts, then that's not unusual. But the last 2 lines of the rules say that if a motion to recuse is sustained, the selection of another judge to hear the case shall follow the same procedure as established in Rule 25.4. Any determination of disqualification shall not be competent evidence in any other case or proceedings. So the way that I understood that, and of course that rule is, cited in other cases, for instance, not for the proposition that the disqualification is not competent evidence. It's just cited in a block cite in Evans versus Williams, 341 Georgia App 226. But that's my understanding. If my understanding is not in line with what the court's understanding is, we would have other arguments against the idea that somehow the recusal of the former trial judge is competent evidence and in some way relevant to whether or not the defendants did or did not do what they are alleged to have done.
Well, it's not relevant evidence as to whether the defendants did or did not do what they're alleged to have done. It cannot in any way be evidence of that.
I mean, I was as to relevance. That was
Okay.
why I was saying.
All right, so relevance will be a separate issue from whether it is, and I can already anticipate the argument, because I would make this argument. What you just read says any other case or proceedings. What does that mean for the case that it happens in? So I think we probably need a little bit more research.
And that is what I sought to do over the lunch hour, but I did not find any Georgia case law that elaborated on that. I didn't find any case law that elaborated on that. And so that was,
all right.
That was where I stood.
Okay. Well, thanks for letting us know what it is you were referencing, and I'm not sure if it actually answers our question or not. And it might not need to, because the relevance issue may be what answers that question, because we cannot, well, and it may be that, I don't know, I will entertain whatever y'all want to submit on that. Either competency wise or relevance wise, although I think I pretty fully understand the defense argument on it, but okay, thank you. So I know we're not quite ready on the Copeland evidence. I think we have sent out some of the transcripts we've got already, so we're not ready on Zachary yet. Are we ready on any part of Zachary? How about the part y'all had notice of?
So, the statements.
Yeah.
I'm a little confused.
It's not even showing that I have a message, but okay. So that's a problem. Yes.
So regarding Zachary, when we're talking about the co-conspirator statements, we've been talking about Mr. Quindarius Zachary in different kind of contexts here. We've spoke of him having approximately 9 hours of statements.
Right.
And we're also speaking about him in context, as I understand it, with the co-conspirator statement. One statement allegedly stated by Mr. Stillwell to Mr. Zachary, that we caught Nut down bad. And then another statement allegedly made by Mr. Kendrick to Mr. Zachary saying we caught Nut down bad. Is that correct? Those are the entire co-conspirator statements to Zachary that we're talking about right now.
Judge,
Yes.
Zachary's interviews, the entirety of those interviews and everything that he alleged that a co-conspirator told him in those interviews are statements of co-conspirators we intend to use in this trial. So he has said, and we identified that because I thought it was pretty specific as it related to the Donovan Thomas murder, what it is that two defendants currently on trial are alleged to have said.
Okay.
But within those interviews, he talks about other co-conspirators and acts, for instance, the shootings, the buying of the shootings of one of the incidents that are alleged as an overt act in this indictment. He talks about his role providing guns to members of YSL.
Okay,
and
so the answer is no, it's not just those two.
right. It's the whole state.
No, it's not just those two.
Right.
It's
Well,
all-
some of
And
the stuff-
so,
my understanding is the state is saying, and I don't know if this is true or not, but the state is saying at this point, to the extent that they know, that Mr. Zachary's taking a stand. So I mean, that's what I understand him saying. And so him saying that he provided guns to people is not a co-conspirator statement if he's taking a stand.
True.
I'm saying what the state is saying is a co-conspirator statement involving Mr. Zachary. The only thing we've has been identified to us is those two statements,
okay.
which are clearly, in my opinion, spilling the beans. I mean, we're in the same predicament as the other. That's going to be our stance, but I don't know. I can't answer the other statements that have not been identified specifically.
The statements that the statements that Quindarius Zachary gave to the police, I'm certain everyone is aware within those statements contains statements made by other people within YSL. When he's talking about the acts that were committed, he is talking about conversations at times that he has with other members of YSL. He
Okay.
may, for instance, at one point talk about what Antonio Sledge told him to do or something of that nature. Antonio Sledge's statements to him would constitute a co-conspirator statement. So to the extent that we have given to them the interviews of Quindarius Zachary and have noticed them that he is our witness, our position is that the interviews and what is within them, it is a discrete set of information that they have noticed that we are using that.
All right, so I think I hear you saying that with regard to anybody named with at least one count against them in this indictment, which is everybody in the indictment, that anything that they say to anybody is a co-conspirator statement, potentially, because they're co-conspirators with the other co-indictees. And anything that they relay was said to them by another either indicted person or person who has admitted in judicio to being a member of this gang is also a co-conspirator statement, and that the defense is basically on notice of that anyway?
If it is contained within an interview that we have given to them,
Okay.
yes. If it is a statement that is made to someone alleged to be YSL, yes. If it is a statement.
Not just alleged to be YSL. I mean, if you're saying they've got automatic notice of this, they need to, it needs to be more than somebody's alleged to be YSL for them to, if you're saying, hey, my notice already based on this indictment and me giving these statements over is sufficient notice.
The only reason I said alleged is that the people here have not, you're on trial. So.
Right, but they're co-indictees.
Yeah.
So I was talking about people other than the co-indictees.
Yes, I see what you're saying. Yes, any statement, yes. To answer the court's question earlier, then yes. To the extent that we have given them that interview, yes.
All right, and so are you seeking to say, and maybe this is where Mr. Shard is asking for some clarification, that for all of those people, which is essentially everybody we talked about, that the most detail you're going to give them is you have their statements,
No,
or are you going to break it down further within the next week?
we will break it down further, but there are only, I think, the people who've pled, and Quindarius Zachary and Kenneth Copeland, who are not indicted, that
Okay.
fall up under that umbrella.
Does that answer at all your question?
Can I explain how it really doesn't, and it's kind of to move from the theoretical,
Yep,
the theoretical to the reality.
yep,
The reality is these statements. For instance, Mr. Zachary gives a proffer. There's like 4 district attorneys and probably 4 investigators in a room with Mr. Zachary and his attorney. The district attorney, you're really the investigators are just peppering him. Well, tell us about the Lil Wayne bus shooting, or tell us about the shooting on, someone's house.
mhm,
And to the extent that, now I get it if Mr. Zachary's saying he was there for a certain event, but there's discussion of a lot of it. The shooting of the convenience store on Cleveland, I'm just making this up,
Yeah,
Cleveland
sure.
Avenue. And I'm just going to use my client's name because he knows I don't mean anything by this. Well, yeah, I think Shannon did that. I think Shannon did that, and that's my understanding. And there's no real. These aren't lawyers asking the question, and there's no indication of what he's basing it on, who told him, who he's saying told him,
right. So
and
you
everything
need
else.
to know in
Right.
more detail.
Who
Is
the
the
source
state,
is.
well, is the state planning to use, I think Shannon did that.
Right.
Is that what you want to know, so that we can then drill down on, is there any basis for that coming in?
Right. I
Is
need
that
to
what you
know
mean?
what the statement is. If the state knows, now obviously if the statement says, Mr. Huey told me this, then I understand that
Yeah,
he's saying the
okay.
source is Mr.
Okay.
Huey, but there's just so much information that's just
Okay.
like being thrown out
Okay.
with no declarant, no identified declarant.
Sure, okay. So first things first is you identify within the next week what parts of each statement you intend to use, because it may be that you are not going to use, I think Shannon did it. And so if that's the case, we won't worry about it any further. So identify them. And if you can also, before the end of the week, before a week's time is out, identify the source if it's not readily apparent, do that as well, but at least get them each statement. And so we'll go from there. Okay. All right. So what else do we need to think about? Because I mean, and I hope we can actually go through more evidence, but all of what we're doing right now is productive, even though we're not hashing out the details. We're at least winnowing, narrowing, which is good. So I don't have an agenda anymore. My agenda got hijacked. What else can we do that's productive today? Anybody have any ideas? Mr. Steele. Okay.
I could get you brief very fast, but I argued this before the recused judge and it was denied. The former judge would not give me a certificate. I took it to the Court of Appeals of Georgia under the collateral order doctrine. I lost. And then the Supreme Court of Georgia denied cert.
Okay.
But there's a ruling on it.
Okay.
So if you don't want to rehash it.
I don't even know what you're going to ask about.
The indictment is fatally defective.
Okay.
So I could take a quick count, if you don't mind, right now, and it should apply to,
Okay.
definitely applies to Mr.
All
Williams.
right. I don't know. I mean, if it is something right offhand, if it Go ahead.
Okay, well,
Go ahead.
it's a general demur. I was going to do it again at appropriate time, but since you asked.
Since you don't have anything else to do right now. Okay.
So in count 56,
You know what? Let me grab my copy of the indictment. Okay, count 56.
I'll get you the page.
Give me a minute.
It's page,
Okay, got it. Page 90.
okay, so that charges Mr. Williams, I'm just using this as an example.
Oh,
It
okay.
repeats charges Mr. Williams with participation in criminal street gang activity. And it gives a date range. And it says the essential elements need to be there while occupying a position of organizer, supervisor, or other position of management or leader of a criminal street gang. YSL did engage in directly or indirectly or conspire to engage in any one of the following acts of criminal street gang activity. And that lists murder, aggravated assault with a deadly weapon, armed robbery, hijacking a motor vehicle. Sorry, I apologize, Ms. Winfrey.
Street gang is.
Okay. Participation in criminal street gang activity for that said accused in the county of Fulton and state of Georgia on and between the 12th day of May 2018 and the 8th day of May 2022, while occupying a position of organizer, supervisor, or other position of management or leadership of the criminal street gang YSL, did engage in directly or indirectly or conspire to engage in any one of the following acts of criminal street gang activity of YSL, to wit, murder, aggravated assault with a deadly weapon, armed robbery, hijacking a motor vehicle, sale of marijuana, possession of marijuana with intent to distribute, theft by receiving a firearm and possession of a weapon by a convicted felon contrary to the law. The state, good order, peace, dignity are up. They're going to repeat, but Your Honor, my belief is that the grand jury, by and through the Fulton County District Attorney's Office, did not allege a material element. There
Okay.
are 4 material elements in violation of criminal street gang activity. And there's going to be a jury instruction that the court, one day is going to give to the jurors. There is a jury instruction on this crime. I'm trying to get you the pattern jury charge that gives the essential elements. And that would be pattern jury instruction 2.02.25. And there's also case law that one of the essential elements is that the crime was committed to further the interests of the gang. That is omitted in count numbers 56 and 57 for Mr. Williams. There are other people here charged, Your Honor, that has the same issue,
Okay.
but they're different count numbers. And the way I understand the law is that the fact that the statute does not give the mens rea, every crime has to have the mens rea attached to it. and that when the legislature or Congress does not include the mens rea, the courts say that the omission from a criminal statute of any mention of criminal intent should not be read to dispense with that essential element. This rule of construction reflects the basic foundational principle that wrongdoing must be conscious to be criminal. And here, and that was, I'm sorry, under MORISSETT versus United States. That's 342 US 246 at 252, 1952. It's also explained in Elonis, ELONIS versus United States, 575 US 723 at 734. It's a 2015 case in Division 2.
I'm sorry, 575 US.
723
Okay,
at 734. It's a 2015 case.
okay.
It's in Division 2B. And that specifically says that the fact that the statute does not specify any required essential element, including mental state, does not mean that one does not exist. And here what happened is there was a challenge years ago under Rodriguez from this courthouse, the Georgia Supreme Court, said in order to save, or that it is a constitutional statute because it's not a denial of freedom of association, because you don't have the right to commit a crime in furtherance of the gang.
Mhm.
That became an essential element. That changed our jury pattern instruction.
Yep.
And our grand jury did not, in our case, did not allege that.
Okay.
So I know that there's a lot of argument about, well, this is a gang case, and then 418 kicks it, 24-4-418 kicks in. But I believe that the charges for the gang is not appropriate. I
And
wrote,
did you say, I'm sorry, did you say that, what did you say the Court of Appeals did?
they didn't take it
They
up.
didn't take it up,
I
okay.
didn't get under Dukes, DUKES. I don't have, Judge Glanville denied a certificate.
Oh, okay.
They never.
I thought you sought, but you did not secure a certificate. So then you took that up under the collateral order rule and,
Did not, they said it's not a collateral order. I
okay.
needed
All
a
right, so they
certificate.
gave you an opinion on the merits of, is this a collateral order thing you can take up?
And
Okay,
and then they dismissed the appeal. So there's no
right,
rule of the case.
okay.
So that is, a couple of counts for Mr. Williams. He has 6. Then the conspiracy, which we're talking about. Okay, I'm sorry.
So you said that with regard to counts 56 and 57, it is not alleged.
I promise that.
Okay.
in those-
And are there other counts that are alleged against your client, Mr. Williams, where that is an issue?
Yes, there's an essential element in count 1,
Okay.
which is the RICO count. And I compared it, I just did it because, it's such a well-known case, to the Donald Trump indictment out of the same grand jury courthouse.
Uh-huh.
Nowhere in count 1 will you see that any of these individuals have been charged with joining the conspiracy knowingly and willfully. It is not in there. And that's RICO conspiracy count starts, I think, at page 12, but hold on.
All right. And so you're saying nowhere in, I'll read it. It's pages 1 through 68 of the indictment, but no, I'm sorry, 12 through 68. You're saying nowhere in that 50-something pages does it allege any of this was to further the interest of the gang?
No, I'm saying that it's a different,
No, that's not what you're saying, or no, it's not in there.
I'm doing a different issue in that, in
Okay.
count 1,
Okay.
the conspiracy.
All right.
The grand jurors charged that Mr. Williams and the others who were here, also the others who are not here,
Mhm.
unlawfully conspired to acquire and maintain directly and indirectly an interest in and control of U.S. currency and other personal property through a pattern of racketeering activity,
Mhm.
in violation of OCGA 16-14-4A, as well as 4B, as well as B. But what happened there is, I went through it hard. There is no allegation by the grand jury that Mr. Williams or anybody knowingly and willfully joined the conspiracy. And under Cotman, which is COTMAN versus State, which is 342 Georgia Appeal, 569, it's in Division 2,
Okay.
the 2017 case. That is a teacher from the APS trial. It was also a RICO conspiracy case.
Mhm.
The Court of Appeals of Georgia held that in order to commit a conspiracy under the RICO statute in Georgia requires proof of the material element that the accused knowingly and willfully joined the RICO conspiracy. That is also in MacArthur, which is McArthur versus Beach, which is BEECH. Haven, which is HAVEN Baptist, BAPTIST Church of Athens. Your Honor, it's 368 Georgia Appeal, 525, it's in Division 3. 890 Southeast 2D, 427, that's a 2023 case. Cotman specifically wrote that under Georgia law, a person may be found guilty of the crime of RICO conspiracy if that person knowingly and willfully joined the conspiracy, which itself contained a common plan or purpose to commit two or more predicate acts. There's also Wiley, which is WYLIE versus Denton, DENTON, which is 323 Georgia Appeal, 161, it's in Division 1. It's a 2013 case where our second highest court wrote the material requirements needed for conspiracy under the Georgia RICO statute is for the person to knowingly and willfully join said conspiracy. There's another case called Z, like in the Honorable Lawrence Zimmerman -space, SPACE, comma, Inc. versus Dan Tanners, DANTANNA apostrophe S, CNN Center, LLC, and that's at 349. Georgia Appeal 248. It's a 2019 case. And what I used also was, I just looked at Donald Trump's indictment. I was interested in it.
Mhm.
He is not only the former president, but the other alleged co-conspirators. They are charged several times with knowingly and intentionally joining this conspiracy. And it's not here for Mr. Williams. And mens rea is a material element of the crime and must be alleged in the indictment. That's in Eubanks, EUBANKS versus State, which is 317 Georgia, 563. It's in Division 4. It's a 2023 case. So, you know, as you're going through this, if you're going to reconsider it, I will bring it up later, obviously, because I believe at a directed verdict motion, that would be relevant as well. But, you know, I don't know what it's like ever to be a judge. And I certainly don't know what it's like to come into a case like you're coming in. So if this helps, this is ripe under State versus Heath, HEATH. Once the jury is sworn, a general demurrer can be made orally or in writing. I actually put this in writing.
Okay.
But I waited till the jury was sworn, and I did that,
Okay.
I mean, intentionally, because jeopardy attached. So.
Sure. Yeah, and if it is already in writing, I'd love to have that. And I assume this got argued at one point before if the
Yes.
prior judge made a ruling. So if there's a written response from the state, point me to where I can find that as well. If there's not, point me to where, like what date it's argued.
I have the order,
Okay.
and I filed that in a motion that I gave to this honorable court.
Okay.
I'll get the motion, I attached it, but I didn't give you my brief. So with the court's permission, and of course the state has it already, but I'll resend it.
Is it filed in the case somewhere or?
Went to the Court of Appeals.
Oh, okay, that brief. Yeah, sure. I'll take it all.
Okay.
And then I'll assume the state filed some sort of a response, maybe not this team right here, but And it may have been that more about that was about collateral order or not, but I'll take it for and read it for whatever it's
No,
worth.
the state argued, and then they wrote the proposed order, which was signed by Judge Glanville. So,
Okay.
and it's a long order,
Yep.
12 pages.
I'll take all of that.
Okay. So I thought that would be, if you grant it, it would be helpful because it would knock out all this work.
Yeah, it would. That is true.
Okay. Thank you, Your Honor.
Thank you.
I'll get you that brief.
All right. Appreciate it.
Your Honor, I'd also point the court's attention to the transcript dated December 11th, 2023. It was filed on that date
Okay.
of at least one of the hearings where we addressed Defendant Williams' general demurrer claims.
Okay. Is it a transcript from December 11th or was it filed on December 11th?
It was filed on December 11th. It was
From-
held on November 20th, 2023.
Okay. Okay. Thank you.
And it was specifically as to Defendant Williams' plea and bar / motion.
Great. Thank you. Appreciate that. All right. Mr. Harvey, you look like you also were maybe going to stand up and come up with something we could do. Oh, and you know what? Hang on. Sorry. If I don't do things when I think about them, sometimes they escape my mind. So I understand that for Mr. Williams, that is count 1, count 56, and count 57 you're alleging are fatally defective. And you mentioned that may be true about other defendants as well. Are there other defendants who either have already made or intend to sometime before this goes to a jury make a similar argument with regard to counts that you have against you?
I think under the rule, we were all joined in.
Oh, right. Yes, the Harvey rule. Thank you. Okay, but if you are all joining in, can you tell me, is this essentially true about every one of the gang counts that they're missing? Okay. All right. Then I can sort out for myself which ones go to which person. All right. Now, Mr. Harvey.
And this is more of an afterthought. At least I'm still having thoughts, whether they're before or after. I want to make an oral motion at this time to prohibit the state or anybody else from talking to witnesses while they're on the witness stand. Judge Glanville would give an instruction which was incorrect to witnesses. Don't talk to anybody but the parties in this case while they were on the witness stand. The only people that are accepted from the no talking rule once a witness is on the witness stand is a criminal defendant and the defense lawyer, because that's a Sixth Amendment impediment. The case, as I remember it, is Perry versus Leak, Perry versus Leeke. It is a United States Supreme Court case, which indicates that other than the defendant, witnesses or parties are generally prohibited from talking to witnesses once on the witness stand. So I would like an instruction. I could write this out. I can ask for an instruction.
That'd be great. I know you don't have to write out the motion. I mean, it's fine. I'll entertain it orally. And I mean, that's generally my understanding as well, but it's been a minute since I've practiced. It's been a minute since anybody raised that issue. Is there some kind of an exception for I know if you're on the stand and then we take a lunch break or a restroom break or something, that's one thing. Is there anything about overnight that is different?
Only for the defendant
Okay.
and the defendant's counsel. That was the whole basis of Perry versus Leak.
All right.
The state said in Perry versus Leak, hey, you can't talk to your client while he's on the witness stand. And the Supreme Court said that yes, because there were Sixth Amendment implications, that a defendant and a defense lawyer could, but generally other witnesses could not.
Okay.
So you're
Hazy
close.
memory.
Yeah. Yep.
All right. Does the state have a response?
Your Honor, I believe that the rule that Mr. Harvey is referring to essentially is the rule of sequestration, and as it relates to other witnesses and about talking about the witness on the stand's testimony. The reason I was looking feverishly is that Ms. Hilton and I had actually discussed this, and I had sent her a case,
Okay.
not from within Georgia, but it literally spoke directly to it. So I was at
Okay.
least looking for that.
All right.
Because I don't think that under the rule of sequestration that attorneys, I think that Judge Glanville had it right, attorneys are not prohibited from speaking to witnesses, but I want to make sure that we get the law.
Let's
to the court.
make sure we get it right. So I'll submit whatever you want to submit on that as well. All right. Thank you all. We're going to take a recess right now if there's not anything we can do immediately. And we will be back at 3 on a Rule 22 matter. Y'all got that notice, right? That there was a new Rule 22 filed?
Yes, Your Honor.
Okay. All right. All right, where's Ms. Bumpus? That's who filed the Rule 22. Good afternoon. All right, so you filed a Rule 22 at, what, 11:10 or so? That's fine. The night before last, so. And you had said that you wanted to start recording for yesterday. And honestly, I didn't even know you had filed it until we were finished with the court yesterday afternoon at 4 something, because it came in so late. And normally the Rule 22s go to our public information office, but I know about it now. And so I have provided notice to all of the parties, and I will listen now to or ask if there is objection from any of the parties or witnesses or victims to the Rule 22 filed by Ms. Bumpus. All right. So I am not real. So what are you looking to do?
Your Honor, I just want to be able to record what's going on in the courtroom.
All right. And you had already, I guess, yesterday live streamed from somebody else's
Yes,
live stream. What is that person's name?
Miss Sylvia.
Miss Sylvia.
Yeah, she's sitting in the courtroom.
Okay. All right. So there are an inordinate number of separate Rule 22s in this case anyway. I'm not really sure why everybody is not using the pooled media that is already, I mean, it's like 8 or 10 media organizations are using one pool, and then there's Miss Sylvia who has a separate one, and then lots of people who have the ability to take still photography, and audio, and it's just a lot. It's like 8 or 9 different things. But I am not sure that yet another person doing essentially the same thing adds to the public's access to this proceeding. There is 24/7 coverage of this, a pooled camera, and Miss Sylvia's separate video recording that you can access anyway, apparently. So, I mean, if you want to be heard as to how that either increases the public's access or helps with the dignity of the court or the administration of justice or the truth-finding function of this proceeding, I'm willing to listen to what you have to say.
Your Honor, I'll be brief. I just would like to say that at any point, these other people who are part of this pool, they have logos and they can pull what I am streaming on my personal YouTube and do copyright issues. They have their own logo on there. And also, I don't always want everything that they are streaming. I don't need the full court hearing all the time. There are specific parts that I need to reference and informing the public of what's going on. And that's my point of being here. And I'm just trying to do everything right so that I can, pass the smell test.
Okay, so with regard to, I mean, obviously you can let the public know anything you want to, and you can video blog, vlog, all you want to, any kind of opinion that you want to about the case. And you can obviously also sit here and watch all of the proceedings. Are you saying that you can't use somebody else's, like the news media coverage?
It has their logo on it. At any time they can say it's copywritten and take it from me. Or
Okay.
from my page.
Have you asked anybody other than, is Miss Sylvia okay with you using her? Because honestly, it's a little bit disruptive to have essentially phones in court. I mean, it ought to be that unless you are somebody who has a Rule 22 already in effect, or you are an attorney in the case, you shouldn't have your phone out or on or anything. And it's kind of chaotic in this entire part of the courtroom. And I find it to be distracting. I find there to be security concerns with having to constantly figure out, okay, who is authorized to have their phone out, who is not. And so what I would like is until there's some point when you find out that you're not able to use somebody else's, what they've already taped. I mean, I'm kind of saying, why don't you and Miss Sylvia be the second pool? Okay, would that work?
We'll try it out.
Okay, so let's do that. Y'all are now the second pool.
You will revisit it if I have an issue.
Sure.
Thank you, Judge.
All right. Thanks. All right. Anything else we can do today? Or did I give everybody enough work that y'all can just go home and do your work? And y'all gave me plenty of work to do also. All right. So we are adjourned for the day. How about we see each other at 9 in the morning? Which doesn't mean when we get the jury back. If we get the jury back, I won't go back to 8:45. But let's see each other at 9 in the morning, and let's be ready to actually work on some actual evidence, okay? All right.
I just want to be clear. What is your expectation of the evidence if you have it?
Are we going to be able to, so y'all are getting some of the transcripts of Mr. Copeland's testimony so far. What all have we already shared? No? We don't have any of his testimony? I thought we had at least the 11th. When are we getting that? By the end of the day? That was a really good question, Mr. Sharp. I thought we were going to be doing Mr. Copeland's evidence tomorrow, but maybe not.
Did we ever get an answer, Judge, as to whether or not we have the transcript from the 10th? I know that Ms. Weaver indicated, excuse my seat, Ms. Weaver indicated that she was working on the one for the 11th. She might have it by the end of today is what I heard earlier. But you asked whether we actually had the 10th, and I didn't hear the answer to that.
The answer to that is no, we do not yet have the 10th. We had portions of the 10th, but they were the other portions of the 10th. So hopefully by tonight, the court reporter will have both the 10th and the 11th. Y'all should have. Now, this isn't his testimony. This is y'all going through evidence, but y'all should have a rough of the 18th, the 21st, and the 24th already. And then the rest of it will be forthcoming. So I don't know if we can work on Mr. Copeland tomorrow or not. I don't know what can we work on tomorrow? No point getting together as much as y'all are all delightful. No point getting together if we can't get work done.
Both emails with CPS, the 18th, the 20th, what you said?
The 18th, the 21st, and the 24th.
Testimony or pictures?
No, so yes, that. So he testified on the 10th, the 11th, and the 12th, and well, wow, okay. He testified the 10th through the 17th. And then y'all took up matters about the evidence surrounding him the 18th through the 26th. All right. I think tomorrow might be more productively spent with everybody working on the things they need to work on. Tomorrow is Thursday, so let's get back together on Friday at 8:45. Okay. See everybody then.